So I want to welcome everybody to the first Earth Talks seminar for the fall semester. Thank you so much for coming. So this fall we have a series of talks that Hannah Wiseman and I are co-organizing, and thanks so much to Erica and to Easy and to Ava for all of their support. And so our sort of theme for Earth Talks this fall is legal aspects of the energy transition. And so we sort of chose this because there are definitely technological elements and social elements and policy elements to this whole process of decarbonizing our energy sector. But all of that technology, all of those kind of policy and social decisions happen within legal frameworks. And in some cases, those legal frameworks are still sort of almost co-evolving with technology. And so there's a lot of sort of interesting aspects to discuss. So we are super thrilled to start this off with a visit from Tara Righetti, who is at the University of Wyoming. Tara is the Occidental Petroleum Professor of Energy Policy. Is that close enough? Close enough, okay. In the School of Energy Resources, and she also has affiliations with the School of Environment and the School of Law at Wyoming. And in her past life, she has basically been legal staff and an executive at an oil company. And so she knows her stuff about stuff. And so with that, I am just going to turn things over to Tara. And those who are on Zoom, I'll put something in the chat about moderating questions and how you all can participate.
Thank you first so much for having me. I'm really happy to be here. It's been a great visit so far and learning about all of the amazing projects that you have going on. And as well, actually, I'm looking for the slide advancer. Is that this one? No, yes. Okay. As well as meeting your faculty and hearing about all the research that's going on here. As Seth mentioned, I have background in oil and gas, which kind of led me into this idea of subsurface law and dirt law, and I've been working in that area in an academic sense, and looking at kind of the intersection between administrative regulatory frameworks and property law, and how those two things kind of play together to create the system in which energy is developed, resources are extracted and used. So thanks for having me. I'm going to talk a bit about land acquisition for carbon sequestration. I think this is one of the things that's most overlooked when we talk about the energy transition. So much is what we focus on is what to build. And there's questions about where to build it. But less attention has been paid to how do you actually get the rights and who are the rights holders who need to be contracted with in order to bring these projects to bear. So what is the scale of the problem? It's really massive. I had to write it down because I knew otherwise I would forget. So I have here 3 different maps of proposed CO2 plumes for you to look at. The one on the left, which is Frontier Carbon Solutions, that's an area of about 12,000 acres. The one in the middle, which is Tallgrass's Carbon Dioxide Southwest Wyoming Sequestration Hub, is about 600,000 acres. And the one on the far right, which is Denbury's, now Exxon Snowy River CO2 sequestration project in Montana, is 110,000 acres. Respectively, the Frontier project is estimated to be able to store over its lifetime 10.4 million tons. And Denbury's is estimated to be able to store about 150 million tons. So these are real commercial scale projects that are being developed. And if you think about the scale of this, it's enormous, right? The Frontier project by itself was 1.5 times the size of State College, right? And the one 600,000 acres in Wyoming that Tallgrass is developing, I mean, it's tremendous. There's a private project as well that's acquired nearly 1 million acres under private contracts to build this. So this is happening at a scale that we really haven't seen before for traditional mineral and and other extractive development, because instead of having like the Bakken oil field, which is very large, which has numerous operators working in it, sequestration means that you need to have this many people with one operator and one person controlling it. Okay, I'm going to hope this works now. Yes. Okay, so it's going to be even more complicated than it seems at first, because if you look at this, and this is the 2013 USGS Storage Resource Assessment, and I've overlaid it, working with our visualization center, with federal and tribal lands. So the assessed and published data is in pink. The assessed not published data is in with the gray dots, and then the stripy ones are ones that haven't yet fully been assessed, so we don't know what their potential is. Collectively, this represents, the estimate was that there's about 3,700 gigatons worth of storage available in the US. But if you notice here, in these areas that are known to have storage, you have things like the cities of New Orleans, Houston, and Dallas, and most of the eastern seaboard, and Portland and Seattle, right? These are large metropolises with millions of people. The Frontier project, that's 12,000 acres, has 10 different landowners. That's possible in Wyoming. If we think about what it would look like to develop a project at scale in more populated areas, in Florida, for example, or in the North Carolina coast, the number of landowners you're going to have to contract with is going to be immense. So we have fragmentation that's happening not only along ownership lines into different parcels, but then you have fragmentation between surface and mineral interests. And then you will have different fragmented ownership within those parcels where people own it as co-tenants, or maybe they own it as joint tenants, and they have different decision-making structures. So suffice to say, the problem of the scale of the problem is huge. If we wanted to use the number of the Denbury project, which is about 800 acres per million tons that is sequestered, what you would end up having and requiring is larger than the total land mass of the US. So of course, that's not how it's actually going to be developed, right? There's areas that have stacked storage, much higher storage potential. But when we think about what is considered geologically, technically accessible storage, and what we think about is commercially accessible storage through contract, our numbers are going to be way, way smaller. Okay, so what is the estate that you're actually acquiring? And I like to think about it as the reservoir estate. But what legislatures have mostly looked at is ownership of pore space. And so pore space as a physical thing with a scientific definition is different than how pore space has been defined legally. And you can see that there's slight nuances between the way it's been defined in Wyoming and in North Dakota. For example, in Wyoming, only the subsurface space, which could be used as storage space, is considered part of the pore space, or the pore space estate, which can be severed. This means, in theory, that you could have an ownership of the pore space, but that the confining formation, which is not pore space under Wyoming law, would still be owned by the surface owner or whoever owned it before. Whereas in North Dakota, it's been defined as a cavity or void, naturally or artificially created, in a subsurface sedimentary stratum. So they've limited themselves to sedimentary stratums. And in this statute, which says that pore space is owned by the surface, we now can say that sedimentary rocks, pore space, are owned by the surface owner, but it's yet undefined who would own the pore space in non-sedimentary formations that might be used for storage. So when legislatures get involved and start kind of declaring ownership and planting flags, these questions of definition are really, really interesting. But they also create complexity in terms of who you need to contract with. So it's kind of unclear at this point exactly what it means to own the reservoir estate. Defining it and what it is, and we've declared in most places that it's owned by the surface owner, doesn't define what the rights of the surface owner are in it. How do you own a void? It's clear that you can own the iterative rock structure that creates the void, and that this is something that's embodied, it's corporal and physical, and can't really be removed from the land itself. But what about owning the capacity for storage, which happens as part of a system that's going to be interconnected with other landowners? It's going to be influenced by pressures, right? And it's full of different brines. That seems like a much more incorporeal interest and much more of a sort of limited common property. But these two things and the way you classify it are going to have legal consequences. If you take sort of the architectural model, which Professor Schrimmer has written about recently, that looks at physical sort of embodied things, saying we're going to treat pore space ownership in the reservoir estate like you would treat an empty building full of windows, which means that something that is put into that building can be a trespass. That creates issues with how that would be enforced and how that could impact sequestration. So the restatement fourth of property says physical intrusions into the subsurface space that interfere with the possession of the person with superior title. There's another section that says with the effective possession of the person with title to the surface of the land are subject to the same principles that govern trespass to the surface of the land. So this would mean that an unauthorized physical intrusion into that space would create a trespass. What does that mean for CO2? In Wyoming, at least, we have defined CO2 as a personal property interest where the property stays with the injector in perpetuity. It never merges into the realty. It never becomes subject to recapture. That's very important for sequestration purposes, but from a property law standpoint, that means that it's an object, even if it lacks maybe the thinginess of objects. And an object placed into the property of another is a trespass. It's less clear what happens in like your area of review where you have pressure plumes and pressure intrusions. Can a pressure intrusion be a trespass? Or is it more akin to a nuisance in that it's diminishing the right of the lawful owner to use and enjoy their property? We may start to find out, right? Sequestration hasn't happened on a commercial scale, but we have our first class action alleging trespass from the ADM facility, which is really the only one that has done significant injection in Illinois. So this is a class of landowners who live around the ADM facility and who own the pore space and are arguing trespass as a result of indirect migration of brines and CO2 into their property. We don't know how this will happen yet. During the actually initial response, ADM claimed that the CO2 hadn't gotten under their property yet, and so the issue was not quite yet ripe for resolution. And based on the highly proven method of looking at Reddit threads, I know that ADM has been out making offers now to lease pore space from these people, and they're talking about how much they should get paid for it on the Reddit threads. So I think we'll start to see what this looks like and how these trespass issues start to get resolved soon. But there's a very strong chance that it will be resolved in different ways in different states. So even this won't totally answer the question. And so to acquire these rights, you're going to have to not only identify the rights holder, but then you're going to have to contract with them. And I think it's a mistake when we talk about sequestration and we only talk about pore space, because what is needed are all of the rights to the system as well as the rights on the surface to bring a project into being. So of course the pore space is necessary, but to do geologic characterization, you're effectively using parts of both the surface and the mineral estate. There's not really a way to explore the surface without learning about the minerals, or vice versa. Can you use, for example, a spec seismic survey that was authorized by a mineral owner to determine suitability of the pore space for the surface, right? When the surface owner never consented to the exploration of the property? Or do you need the mineral owner's consent before you can assess whether that area is suitable, because you would have to prove the absence of producible minerals in order to get a permit? The right to inject and store typically is owned by the surface owner, although Hannah and I were just speaking about how that's less clear when you get into unconventionals. When you're storing in a coal estate, for example, the CO2 absorbs into the coal. The mineral is the iterative rock structure. Can we still say that it's owned by the surface owner and not the mineral owner when you can't have both uses at the same time? So there's questions of identification, and then also the issues of contracting. To do corrective action, which means fixing old well bores for mechanical integrity, you're going to need to contract with the mineral owner. And from the one example I've seen, the mineral owner wasn't super keen on the idea of somebody else coming in and messing around in their producing wells and wanting to re-cement them. There is no mechanism to force the mineral owner to allow you to do this. And even like the oil and gas regulators really can't force them to allow you to do corrective action on their well, which means you're going to have to contract with them. In the case I saw, they said, great, buy our oil field, pay for the value of the oil, and you can decide whether you want to recomplete these wells or not, right? But we don't want other people coming in and messing with our operations. Drill through restrictions are also potentially important, which would allow you to say, before any new drilling that goes through my storage complex to produce minerals underneath it, we're going to have to put restrictions on the ability or the methods or the right to develop that. The mineral owner may need to grant those permissions as well. And then the surface owner would obviously have to grant them for drilling through restrictions in surface-owned formations. And then you're going to talk to the surface estate owner for facilities, ingress, egress, and post-injection monitoring. In Wyoming, we're able to also sever the pore space as a state, which you can't do in North Dakota. And that says that there are no implied rights of use or access. There's no implied easement to use the surface for development of the pore space. So those rights would have to be specified in the deed conveying the pore space, or they would have to be separately acquired by contract. So how do we do this? This has been one of the most fun projects I've ever done. And what we decided to do was look at how parties were actually contracting for pore space on private land and how these agreements were structured. What we ended up doing was looking in state land offices, county property records. We did a lot of public records requests for things like water districts or irrigation districts, school districts, right? These are land-owning public agencies that are subject to public information laws and therefore would have to disclose these contracts. So that's how we got our data set. We did a ton of company outreach, and maybe this will surprise nobody. A lot of people were very happy to sign NDAs and then share nothing. So that we didn't have any luck with that as an actual method. Ultimately, we were able to get leases from California, Colorado, Louisiana, Mississippi, North Dakota, Texas, and Wyoming. We found hundreds of memoranda covering millions of acres, but relatively few full agreements. So the memoranda, which basically say for recording law purposes, there is an agreement on this property, but don't tell you any of the juicy stuff, we can kind of see what the scale of leasing is and where it's happening for these different projects. But to actually look at the compensation structures and how these are being treated and structured, you need to have the full agreement. Oops. So we found easements, leases, deeds, rights of ways, options, and joint ventures. So this is taking a lot of different forms. I think it's really important that you have some sort of easement or perpetual interest, because a lease by itself would have to have an expiration date at some point, most likely. So because of that, right, there's this question of what happens when the property interest terminates, the lease ends, but the CO2 is still in the ground, right? That might mean that one person has the legal obligation for monitoring, reporting, and verification, but another person owns the land where that activity will have to happen. That's something you want to avoid. Here are two kind of screenshots of some of the agreements that we found, one from Texas and one from Colorado. In general, the agreements are broken up into several different terms. You have an initial term and a permit construction term. Some of the leases put these together. Other ones treat them as separate. But generally, this is the time in which geologic characterization activities happen, in which there's the right to go and seek a Class 6 permit and the right to construct a well. Then there's the operational term, which is the period of injection, and then a post-operations term, which is your MRV term. This kind of segmentation, I think, is super important because the compensation is also segmented. So each of these different stages has a different compensation structure. Okay, so what are the common compensation terms? During that initial term, we're seeing a bonus in every single one of these agreements. That just gives you the execution of the agreement. Some of them include per acre annual rentals, but not all. Then in the operations period, you have volumetric payments. And then these are often sort of triggered or tied to either tied to the volume of CO2 that is being injected, but then also to measures like 45Q or the value of carbon offset. So some of them, like the Texas agreements, use a royalty structure where the landowner gets 6% of the value of any environmental attributes that is created, whereas in all of the other states, they have a fee per ton, so more of a tipping fee model. But then there's these escalators or adders. For example, Colorado says, we get a fee per ton, that's going to be our baseline, plus 3% of anything else you pull in over and above the current value of 45Q. We see minimum injection provisions, but these, based on the way they're structured, we found really don't matter very much because they're so small compared to potentially the value of the contract that I don't think they protect against what is the biggest risk to the landowner, which is underutilization. They may protect against periods of low injection, particularly early on when they're still getting offtake agreements and drilling wells. But the bigger risk to the landowner is that somebody injects a little CO2, but not all of the CO2. Because of the liability and other frameworks, it's very unlikely that somebody's going to come in and use the rest of that resource. Or to do so, they would have to take on the liability of the prior injector. So the bigger risk to the landowner is that the resource only gets partially depleted, but that has the effect of full depletion. I was really surprised not to see things like we see in federal coal leases that say, you know, this is the amount of CO2 you think you're going to put in the ground, and this is you're going to owe us the fee per ton or 80% of the fee per ton, whether or not you put it all in once you start injection. That wasn't in there, which is something that I had expected. There's also no PEW clauses, which was another thing I had expected. We saw, again, the fee escalators, and then probably the most important thing were most favored nations provisions. And this is where things have gotten really interesting. It's where the landowner says, and this has its like basis in trade law, but I want to get the best deal that you give anybody else for pore space in this project. Where it's become really interesting is that what landowners are saying is, I want to get the best deal for pore space that you give anybody in the state. And then for some of these really big companies, I've heard of them saying, look, I want the best deal for pore space that you're willing to give anybody in the country. But this ignores the fact that pore space as a sort of exhaustible resource is heterogeneous. It's not all worth the same amount. But these most favored nations positions can kind of create this constant ratcheting up of values. Although what we're seeing is they're only tethered to either volumetric fee or bonus. And so often the most favored nations agreement would be like maybe tied to the volumetric fee, and then the negotiation is really happening around the bonus because the company says, look, we're only paying everybody the same amount. So we tried to compare these and look at the different payment structures in each of these different stages about how much is getting paid. You can see that the agreements have some differences and that the amount that's paid really differs. For example, Louisiana has between $1.50 a ton to $7.50 a ton as the different payment amounts in their agreements, whereas Wyoming is a flat fee with a CPI adjustment. Colorado is interesting in that it has both the flat fee and the royalty. Texas has just the royalty. And only Colorado requires a rental during the MRV period. All of the other ones, the obligation to pay compensation ceases at the termination of injection. So then I was able to work with my colleagues, Brian and Diana, as well as with Tim Fitzgerald from Texas Tech, to try to figure out what this actually looked like as a present value per ton of pore space in these different states under various different scenarios. And what we're doing with this project now is really trying to refine those development scenarios and make them more realistic. We did a bottom-up approach where we used the storage resource assessment based on where the lease was, and then based on sort of the estimated pore volume per acre, we made the assumption that the pore space would be fully utilized. We know that's not true, but that was sort of the only assumption we could make consistently across the board, because some companies have, like Frontier and Denbury, have announced their anticipated annual injection rates, whereas others have not. And so we tried to say, what data do we have that's the same for everyone? At least that should give us a sense of relative value. But I think these are likely overstated. So we looked at sort of the baseline 45Q payments based on point source capture right now with a 12-year period. We looked at minimum injection provisions if they were only injecting the minimum. What would happen if you were able to claim some carbon offsets? And then what would happen if 45Q tripled, to try to kind of get a sense both of PV per acre and PV per ton. And you can see there's a very large difference here. And what I think is interesting is that in some cases, this is a lot of money if you have a lot of land. But in others, like in Wyoming, if it is $3,000, for example, an acre, and you have a tenth of an acre, are you really going to contract for a perpetual interest in your land for $300, right? Within areas where land is highly fragmented, it's possibly not enough value to the landowner to induce the parties to contract. So then we went and we interviewed a bunch of different project developers to try to figure out why we see this heterogeneity of values. What came across the board the most was they said, look, you have to have a Goldilocks project. One size fits all. You need to have the right injectivity rates. You need to have be close to pipelines, be close to CO2 sources. You need to have, obviously, suitable trapping and confinement mechanisms. You need to have a supportive population and a good regulatory framework. So, of course, everyone says we want it all to be just right, But then when they had to rank them based on importance, we really saw that the most important things were going to be kind of the risk of leakage being low and the kind of storage capacity being really important, as well as like injection rate per well. So those technical factors ended up being more important than the non-technical factors, but you really need all of it. Okay, now we're going to pivot. So we started then looking at federal pore space. So federal ownership, I have this same map again. Yellow is federal, blue is tribal. The big kind of takeaway for this slide is that federal lands aren't necessarily uniform either, that they're split against all of these different land management agencies, each which have their own rules, which say whether or how they can give rights of way or other rights for storage. Multiple use agencies are mostly BLM and Forest Service, but then you have all these dominant purpose land ownership agencies like the Department of Defense, the Department of Energy, the Fish and Wildlife Service, and they can only grant rights if it's consistent and compatible with the dominant purpose. Right? So Department of Defense will only grant rights of storage in defense lands if it is consistent and compatible with military readiness, for example. Ownership of pore space typically follows the surface in federal lands. And there's a case right now which will be heard next month in the 10th Circuit, which is True Oil versus BLM, where BLM has said, even though pore space ownership follows the surface, if you're traversing through federal minerals, you still need a federal APD because the federal government needs to protect the mineral interest. So tribal lands are their own thing. Ownership statutes like the one in Wyoming do not apply to federal lands. They do not apply to tribal lands, right? The state legislature cannot reinterpret property rights that are established by treaty. But then in tribal lands, you have trust and allotted trust and fee lands and split estate. And so sometimes you're dealing with the tribe, sometimes you're dealing with tribal members. But under the right-of-way granting authority, you would need not only the approval of the Bureau of Indian Affairs or the trustee management agency, but also either the tribe or a majority of the tribal owners. We don't have a lot of guidance on this. The Forest Service is going through rulemaking right now because their current rules say that anything that's a perpetual use of land is ineligible for a special use permit. So you don't even get to the stage of negotiating because under the initial review criteria, sequestration would be counted out. Then in 2022, BLM put out this authorization and guidance. I understand there's other guidance that's in the works that should be out very, very soon. I heard that it was going to be out in the summer, last summer, but it obviously wasn't. This one, though, expires about a year from now, so it should definitely be out by then. And this says that the authority is under Title V of FLPMA, which is the Federal Land Policy and Management Act. And that allows granting of rights of way. So it's not a lease under the Mineral Leasing Act, it's a right of way. And this says rights of way for pipelines and associated storage facilities. So these statutes mandate that rents for federal land reflect fair market value. So what is fair market value and how do you do this? So part of our project was looking at all the different ways that the federal government has assessed rentals before for other types of land uses that have something in common with carbon sequestration. This part of the project often felt like kind of a how is a raven like a writer's desk, where from Alice in Wonderland, where the answer is it's not. So we tried to say, how is carbon sequestration right-of-ways like a wind right-of-way? How is it like an oil and gas lease? What can we learn from these different methods to try to figure out what's the best way to assess rentals at a fair market value on federal land? A few takeaways is that you have to consider it based on the highest use at market value, and that land management agencies can't say, well, Congress clearly wants there to be sequestration, so we're going to make this cheaper, right? We're going to give it away for free. Now, Congress could do that under their disposition authority. And there's a lot of lobbyists who are arguing that they should, to try to make CCS on federal lands more attractive. But the agencies themselves don't have any authority. So what would happen is you file a standard form 299. You have to file a cost recovery agreement and a plan of development. Then what's going to happen is it will go to the Appraisal Valuation Service Office, which is an independent appraisal agency within the federal government that will usually use third-party appraisers to come up with an estimate of fair market value. And then that goes back to the company, and they say, here's the rental that was assessed and appraised. It's kind of a take it or leave it, but it's really a take it and appeal it or leave it. So there is a right of a party then to appeal and say that the valuation is too high. So oil and gas uses a bonus and royalty. Produced water uses a rental schedule. I thought this was really interesting that it's an aerial rent plus a per barrel injection fee, so more like a tipping fee. But it only applies if the injection is happening on federal land. There's no accounting for indirect migration of produced water injection into federal land. My theory is that's because when you inject produced water, the injector gives up title at the point of injection to the produced water. They can't go back and claim it's still theirs, whereas with CO2, they hold on to that title. I see that as being a really important distinction. Natural gas storage is interesting because it's the value of the storage, the income generated by the operator, plus the injection and withdrawal volumes that can determine the value. And then renewable energy right-of-ways look at sort of a capacity charge and an encumbrance fee, but it's more like a rate of return on the renewable resource, and it's not treated the same as an exhaustible resource. Okay, so how do you overcome these different challenges? It's very unlikely that we're going to get unanimity. And there's some question of whether unanimity is really needed. And I believe it's needed as a result of commercial concerns and as a result of liability and regulatory concerns, but not necessarily from a technical perspective. And I really feel like we should question frameworks that require unanimity, because what it really is likely to create is waste of the pore space resource. So when I say commercial concerns, right, the company will have contracted for offtake from emitters for a certain volume. They have a contractual commitment to be able to put that volume into the ground. And they want to make sure that they can fulfill that. So they want to cordon off as much space as possible, plus a decent barrier, which acts like a moat, to make sure that other injections and pressure intrusions aren't going to affect their injection volume. From a liability standpoint, it's going to be because if there's MRV responsibilities and stewardship responsibilities, if those plumes start to commingle and there's a loss of containment, there will be a question of whose responsibility was it. If the only way to get site closure and certification is to prove that your plume has stopped expanding and stabilized, you need to make sure that nobody is injecting anywhere with connectivity in a way that could affect your plume movement so that you can validate your models about stabilization. You're also going to, it's unlikely because first, negotiations might fail for some owners. I actually think this is really likely where land is fragmented because the value might not be enough. A landowner right now would be really reasonable to say, I'm just going to wait and see. I think the value of my pore space will be more 10 years from now than it is today. And the value you're offering me today, if it's a couple $100, isn't really worth it to give up that, to take on that opportunity cost. So I think negotiations will fail. sometimes you're just not even going to be able to identify or locate all of the owners. And that's a real problem, right? You may have unprobated wills. You could have like heirs property. It may be very difficult to contract or find all these parties. Or you're going to have multiple companies leasing in the same area. And so you won't get unanimity because there's competition for the resource. So one way to deal with this is expropriation. Indiana is the only state that I was able to find. Louisiana used to have expropriation for carbon storage, but they repealed it this year in June, so they no longer do. But Indiana permits condemnation, but it's limited just to one project. So they authorized it for the Terre Haute pilot project, which in a very specific area. I think they've set the value for this at 125% of fair market value. So because they're granting this condemnation right, if it gets to that point, the operator's going to have to pay more, which makes me question, well, who wouldn't then? If fair market value is determined by negotiations and by not negotiating, you get 125% of that, there's not a lot of reason to negotiate. The more common approach is through amalgamation. Amalgamation is like unitization in oil and gas. In Wyoming, we call it unitization. In Indiana, it's called integration. I think Illinois says integration too. It's called amalgamation in Texas. So different words for the same thing. But effectively, you need an agreement to create a unit that's going to be ratified by 80% or 60%, depending on the state, of the owners of the pore space capacity in that unit. This is, then they get some sort of payment, right? And in Wyoming, it says that they will get their proportionate share of the value that's paid to other consenting owners in the unit, and you basically imply a lease. It's unclear if this would apply to federal lands. The Frontier Unitization Permit proposes involuntarily unitizing federal lands. I think there's some preemption arguments that could be made there. It only works for minority holdouts, right? If you don't have a way to contract on a large scale, you're never going to get to 80%. And I think there's a vulnerability to constitutional challenges because unlike production of oil and gas, and I'm really torn here because I think unitization or something like it is necessary if carbon storage is going to work. But it does challenge the way that we think about the right to exclude and the right to possess, because it is different to put something into property than it is to take it out. And if this is condemnation by another word, which Wyoming statute, in a bit like explains itself too much. It says, and by the way, this isn't condemnation. But if it is, this doesn't provide the same protection as the takings clause, right? The takings clause doesn't say somebody can use your property if 80% of your neighbors agree and you get the same contract that they got for themselves, right? And it doesn't say that a commission of political appointees gets to decide if that's reasonable. But that's what happens in unitization proceedings. And landowners in North Dakota are challenging the constitutionality of unitization orders that have been issued under sort of a Loretto teleprompter analysis. And so that's still working its way through the court. An interesting factor of the Indiana law is that the Indiana law says, and by the way, you can't sue for trespass. So it has tried to take away kind of the common law remedy that would otherwise be available. So OpenAI gave me this great version. I said, imagine a direct air capture in farmland in Pennsylvania. And so I really think that this has kind of created this frontier. It's a frontier in the theoretical sense, right? There's a land rush that's happening, right? There's this rush for tax credits. There's a lot of new wealth that's being created, new laws that are coming into being. And land is going to be a huge part of this, as with other sort of frontiers. And so we see this land rush. But our research, for example, only is looking at contracts that exist. In most places of the country, there are no contracts, right? These projects aren't happening because the value isn't there yet. But when we look at the land rush and things like expropriation, things like unitization and this mindset, it really, to me, makes me question, are these mechanisms enough, right? Does this sort of delay our efforts to bring these projects to bear? Does this delay or impede the scale of carbon sequestration? Does this make it more climate mitigation more costly for all of us? Which ultimately, like if EPA's rule goes forward, power plants need to have CCS, they're going to need to acquire pore space from landowners. All of those costs are going to be passed on to ratepayers. So do we need other mechanisms in place? And this really challenges me because right now we treat CCS like oil and gas. We've created an incentive, voluntary carbon markets, offsets, but also the 45Q. And it's kind of the brass ring of saying, maximize your profit, right? If you can get the CO2 in the ground, you can claim this, and all of the profit goes to your shareholders. That's different than the way we've approached other large public infrastructure projects that are needed. For example, how did we, not that it's the way we'd want to go, but how do we develop highways or railroads, right? In ways they're looked at this as being a public infrastructure project for the public benefit. Whereas these projects are private commercial enterprises. How much of the state's power do we want to flex to allow takings of private property for these private gain, even though the sequestration itself is a public benefit? So there's this mix of private and public. I think this would question us to say, what might other models look like? Like, should a utility model be examined? Should you look at, public land acquisition mechanisms? I was really intrigued by, for example, the Bankhead-Jones Farm Tenant Act or the Weeks Act. These are areas where, through voluntary transactions, the federal government acquired and assembled very large resources. Actually, like a lot of the forests around here were created through the Weeks Act. They were lands that had been sort of denuded of their timber and had very low value for farming. And so through congressional appropriations, they were able to come in and repurchase those lands to create some of the national forests. Should we be looking at models more like that? Right now, I would argue against the idea that we need to give away public land pore space at a reduced cost or for free, because really that's just creating a windfall for these private actors that are conducting those projects. It doesn't mean that the costs are ultimately, or the benefits are going to be passed on to the public for uses of public land. So this has been something that's kind of really challenged me, because on the one hand, I think these projects need to happen. And our climate models say we aren't going to get anywhere near 2 degrees if they don't happen. On the other hand, the way that we've approached it, which is really trying to get the private sector to do this for a profit, challenges my belief of how much and what is the social contract about how much the government can sort of impede upon individual rights for the benefit of other private enterprises. So that's kind of where I've been stewing lately. I've been really interested in, like, particularly for federal lands, could we looked at like a spectrum allocation model? What are some of the alternative frameworks for allocating resources other than this, let's chop it up into blocks and lease it off to the highest bidder? How can we create more efficient resource use? And how do you deal with these multi-jurisdictional issues? So we have two publications that are coming out on this. One is called, both I've written with my colleague Maddie Lewis. If you haven't met her yet, she's absolutely fantastic. One's coming out in Boston University Law Review called The Valorization of Federal Pore Space. And the other, which is in Columbia Journal of Environmental Law, is called Contracting the Void, Land Capital and Sequestration. So that produces a lot of these. Both of them will be out spring 2025, but they're on SSRN. I didn't do any of this work by myself. Here's all the wonderful people who were part of this project. It was also funded by the Department of Energy under a cooperative agreement. And so a lot kind of went in place to make this kind of empirical work possible. And then there's my contact info if anyone has any questions and wants to reach out. So that's it, I think. Thanks. So I'm happy to take more questions. So the question is, how deep do property rights go? And so there's some really interesting work on this, which Hannah and Seth have actually sort of responded to on, what is that article called? Owning the Center of the Earth, is that right? By John Sprankling, really, really interesting piece that kind of questions this of how far can we extend this notion of dominion and possession that would give rise to private property? Courts haven't looked at this in a direct way of saying, like, at some point title is extinguished. But when we look at the remedies that have been awarded for subsurface trespasses, especially through indirect migration, that indicates that courts do look at the nature of property interests and the rights of exclusion as being more limited. For example, the damages are often nominal or these claims are like failing based on issues of proof, but very, very nominal damages, which sort of acknowledges the intrusion but doesn't allow the same kind of rent seeking. That is where it's like the same activity, if it was happening on the surface of the land, the party would be able to claim probably more damages. Now, I think, though, that we still need to figure that out, because when they've not allowed damages, really the argument has been pore space had no value before and you weren't using it anyway. And so this ignored the fact that clearly it had value to the person who effectively appropriated it through indirect migration. Because if they hadn't just indirectly migrated, they would have had to contract for it. So that party appropriated the value of the contract. Whether courts, like the court in Illinois, will start to look at that and say, there's almost like an assumpsit type of argument that somebody has taken for themselves something they knew they should have been required to buy or purchase. And so as like pore space markets become more and more developed, and you start seeing private transactions in areas and you can put your finger on a market value, I think that courts will be much more likely to find a loss of that value and award more damages than they have previously. What the first question was about, how do you sort of acquire the geophysical geologic characterization rights, and who do you get those rights from? I mean, the sort of answer that you would give a client would be get them from everybody. What I think we've actually seen is that, and there's a bit of like, if it's good for the goose, it's good for the gander, because mineral owners have been granting geologic characterization and seismic permitting rights without asking the surface owner, for forever. And they've been collecting data about the surface while they're collecting data for the subsurface. And so if the inverse is also true and the estates are truly of equal dignity, it would say if the intention of your exploration is to learn about the surface, a surface-owned resource, you should be able to get permission from the surface, notwithstanding the incidental collection of information about the minerals. I think I've seen a number of different approaches in terms of how people are actually contracting for this. most people are getting rights from the surface owner for new seismic surveys or characterization wells, but then notifying and making nominal payments to the mineral owner, very small kind of payments just for the right to traverse through the minerals as part of that if they're drilling a characterization well. I think there should be sort of a fair use doctrine that any geologic information that was lawfully acquired should be available for any fair use, and we shouldn't kind of taint it. Like if it was only acquired with permission from the mineral owner, it should only be usable for mineral use forever after. And then the second question was about how do you rank the dominance of the estates? And at least in Wyoming and in most states, the mineral estate is seen as the dominant estate, whether or not it's the more valuable estate. So even if this was like the best carbon storage, resource ever and had a huge potential public benefit, in a split estate, the mineral owner would still have the dominant rights to extract and use that land as is necessary for extraction of the minerals. Now, split estate statutes, which are enacted and require surface damages in a lot of states, if you actually developed a sequestration project, for example, in Wyoming, and a mineral owner came and wanted to drill through that, the Split Estate Act would require compensation for loss of value, loss of the value of improvements, and loss of income. And so if the use and the potential harm exceeded the value of the minerals, that statute is actually going to kind of flip it where the mineral owner isn't going to develop because the liability that they would owe to the surface owner would exceed the value that they could produce. Not all states have that though, and so it's going to differ. Okay. Okay, thanks, Michael. The question is, risk to landowner reminds me of all the shut-in wells here with fracking. Got bonus, but no royalties. Missed the beginning of talk, but you did mention extent of CCS currently and percent of land-based geology in US that may be appropriate. So I did mention the second part, which is that if we were actually to use all of the technically accessible storage capacity in the US, much of which underlies like very developed areas and cities, it would still be a very large area, depending on the assumptions you make of how many acres you need per million tons of CO2 that can be put into the ground. It's very large. We're seeing projects that range from, the Frontier project, which is 12,000 acres for its actual free CO2 plume. The area of review in the pressure plume is 162,000 acres, right? So it's an order of magnitude larger. So these are very large scale projects, and some of the projects I mentioned are up to 1 million acres, where you have lower quality resources. The CO2 is going to spread out more, and so you need more land for the same amount of storage. And then the second question is all of the shut-in wells. We do require corrective action on that to prevent them from being conduits for loss of containment. But if also sort of the question is, what happens if this goes bust, right? And you have all of these contracts people have paid, bonus, and sequestration. You drill wells, you put a little bit of CO2 in the ground and it never gets off the ground. And there's a lot of risk here about questions of like whether 45Q will be reauthorized. Will, the voluntary carbon markets continue to develop and sustain this? I do think, you think of like the CBM analogy that you drill a ton of wells and then 6 months later, all the companies are bankrupt and who's doing that stewardship? The Class 6 framework is supposed to control with that, with these like very high financial assurances that go way, way beyond costs of well plugging. So hopefully, that would mean that the state would be able to step into their shoes to prevent harms and risk to the environment relying on that bonding. But you're absolutely right. The track record isn't amazing. Hannah, did you have a question?
And just quickly, I think this is a good one. How much CCS is there now, and is the amount of CCS that's going to happen, is it primarily driven by the subsidy right now? I think that's worth it.
Yes, yes. I think it's very much right now driven by the subsidy. The subsidy right now is enough to be economic for capture by itself for ethanol plants and gas separation plants. You have to add on an additional incentive in a private market way in almost all other cases. So if you want it to work for cement or steel or pulp or paper or coal fire capture, you're going to need something in addition to the tax credits. In our qualitative interviewing with CCS developers, 100% of them said that they are claiming offsets in addition to 45Q. Nobody would say how much, because we wanted to find out what is that as a percent. It's really hard to determine the value of something of like a slice of the pie if you don't know how big the pie is. But because that's totally unregulated, there's really no transparency. I've heard that it can really vary from like $20 a ton to $500 a ton. I think based on the amount of bonus that is paying in contracts that I've seen and heard about that weren't part of our data set because they're not publicly available, in some cases, the company's paying more than the value of the 45Q credit, which indicates there must be a very large additional offset that's being added to that.
Okay, in 2 minutes, this is too much for 2 minutes. I was really intrigued by the idea of a public utility model, because to some degree this is a natural monopoly. I mean, it's a land monopoly, but it's also it has natural monopoly characteristics, high cost of entry. We don't want a lot of overlapping infrastructure with respect to pipelines. So just curious about your thoughts about public utility model for CCS.
I actually think it might be a better model. In the long term, right, public utilities do have rights of condemnation on a very large scale. Now, the administratability of condemnation of land on this kind of scale is still very difficult, right? To go through that process would take forever, but you would have the benefit of like regulating the amount of profit, of assuring the project is of a public benefit or is for public use, meaning that you can't monopolize the storage resource so that only one emitter can access it or only one pipeline company can access it. There's a lot of questions on how that would work. Professor Schrimmer actually wrote a thing about how a public utility model would work in Kansas as part of a carbon safe phase 1 project, and it's really interesting. So he actually looked at what would like draft legislation authorizing public utility regulation of CCS look like. I do think it would overcome some of these challenges, and then you would have to also, I guess, and this is sort of the other question of how do you deal and what are common carriage and non-discriminatory access and 2 pipelines and 2 storage facilities, right? What does that look like in an area, and how would you actually regulate the markets in that case if you were to make it under kind of more of a public utility model? I think that's a fascinating question because we only expect the demand to grow. And so you might not have like depletions and more capacity becoming available. So how do you oversize the infrastructure or anticipate what's going to be needed? It clearly doesn't make sense to prorate people. If somebody puts in the capture infrastructure and then somebody else puts it in and there's not enough capacity, telling both of them that they should vent half of their CO2 makes no sense. So I think there has to be some sort of first come, first served element to make sure that people who are investing in capture are assured offtake for the life of their facility. So I think that's a really interesting question.
I think we are at time, but let's thank Tara and thanks to everybody who's on the video.
Thank you.